Okay, let's dive right into this explainer. Today, we're unpacking a really fascinating legal journey that went all the way to South Africa's Constitutional Court back on September 11th, 2003. We're looking at case CCT 32-03. It involves a man named Ahmed Raffik Omar and his major clash with the Domestic Violence Act. Now, what makes this case so incredibly captivating isn't just the core legal argument, though, trust me, that's interesting enough, as it deals with that super delicate balance between immediate domestic violence protections and our fundamental constitutional rights to freedom. No, what really sets this apart is the wildly unexpected procedural traffic jam that dragged the whole thing up to the country's highest court. Here's our roadmap for today. We'll start with the Domestic Violence Act itself, then move on to the constitutional challenge, hit a roadblock in court, explore the attempt at seeking direct access, and finally, look at the court's final decision. All right, Part 1, the Domestic Violence Act. To really get why this conflict erupted, we need to zoom in on the Domestic Violence Act 116 of 1998, specifically Section 8. Let's strip away the legal jargon for a second. How does it actually work in the real world? Well, it sets up a pretty unique three-step mechanism. Step 1. When a court issues a protection order, it's legally required to simultaneously issue an arrest warrant for the respondent. But, and this is a huge but, the execution of that warrant is suspended, as long as the respondent follows the rules of the order. Okay, Step 2. If the complainant later files an affidavit swearing the order was breached, they can take that suspended warrant straight to the South African Police Service. Then, Step 3. The police have to step in and assess if there are reasonable grounds to suspect the complainant might suffer imminent harm. And this brilliantly illustrates how the law tries to actively prevent immediate danger. I mean, it literally places a powerful preemptive tool right into the hands of the protected party and the police. But the police can't just act blindly, right? Section 8, subsection 5 spells out exactly what they have to weigh when judging that imminent harm. They've got to look at the risk to the complainant's safety, health, or well-being, the seriousness of the alleged breach, and how much time has actually passed since the breach happened. If they look at all that and say, yes, imminent harm exists, they have to arrest the respondent right then and there. But what if they don't? Well, if the grounds for an immediate arrest just aren't there, the police hand the respondent a written notice. This notice basically says, show up in court on this date to face a charge. The officer then sends a copy of that notice to the court clerk, which acts as prima facie proof, basically on its face evidence that the notice was served. So you can see it's a highly structured system built for swift action.
So that brings us to Part 2, the constitutional challenge.
Now that we've got the mechanics down, let's meet the main player here, Ahmed Raffik Omar. His wife, under Islamic law, Halima Jusab, had actually used this exact act to secure several protection orders against him. Well, Omar went to the courts arguing that an arrest warrant against him had been irregularly issued. But he didn't just challenge the warrant itself. He went much bigger. He took aim at the entire law. His core claim was that Section 8(1)(a, that's the rule forcing a judge to issue a suspended arrest warrant the exact moment a protection order is granted, was a fundamental breach of his constitutional right to freedom and security of the person. To fight this, he brought in some heavy hitters, citing the government of South Africa, the Minister of Justice, and Ms. Jusab as respondents. Let's move to Part 3 and see how this builds. A roadblock in court. So Omar takes his grievance to the High Court in Pietermaritzburg. Now, you'd probably expect a massive, fierce legal battle here, right? Especially when a federal law is on the line. But instead, we get this incredibly strange procedural vacuum. Get this. All three respondents, the government, the Minister of Justice, and his wife, filed notices stating they intended to abide the decision of the court. In plain English, they decided not to oppose Omar's application at all. They basically just threw their hands up and said, we're staying out of it, we leave it entirely in the court's hands. And this total lack of pushback led to a seriously shocking inciting incident on our timeline. On July 29th, 2003, the matter finally lands in front of the High Court judge. The judge takes one look at the situation and just strikes the case off the roll. Boom. Just like that, everything grinds to a halt. You're probably wondering, why on earth would they do that? Well, the judge felt that the government and the Minister of Justice had a clear obligation to explain exactly why they weren't fighting a declaration of constitutional invalidation. And since they gave zero reasons, the judge outright refused to hear the case. This sets up a massive clash in legal philosophy. Let's look at how the Constitutional Court eventually viewed this whole mess. Spoiler alert, they emphatically said the High Court got it wrong. Now, they agreed that hearing the executive branch's side is super important. I mean, challenging laws passed by Parliament is not some minor formality. Parliament debated it, state law advisors certified it. If the government isn't going to defend its own law, they really need to explain why. But the Constitutional Court pointed out that the High Court judge shouldn't have just tossed the case. They should have paused the application, adjourned, and officially requested those affidavits. Simply striking it off the roll? Yeah, that was definitely the wrong move. All right, moving on to part 4, seeking direct access. But Omar, well, he wasn't about to just sit around waiting for the High Court to change its mind. Feeling totally locked out, he pivoted to a brand new strategy. He grabbed a procedural tool called an ex parte application for direct access under Rule 17. Now, ex parte basically means he went rogue, bringing the application forward unilaterally without the other parties. And direct access means exactly what it sounds like. He was trying to bypass the usual, agonizingly slow appeals process, skipping the Supreme Court of Appeal entirely, to cut the line and drop his constitutional challenge right onto the desk of the Constitutional Court. So that brings up a massive procedural question. Did exceptional circumstances actually exist to grant direct access here? You see, the Constitutional Court doesn't mess around with this. Their rules are incredibly strict, and direct access is a super rare privilege. You absolutely cannot show up at their door because a lower court annoyed you. You have to prove, beyond a doubt, that your situation is so exceptionally urgent that it demands immediate top-level intervention. Which brings us to the final chapter, Part 5, the court's final decision. Here is the ultimate climax of this legal journey, handed down by the full bench. The Constitutional Court didn't mince words. The application for direct access was firmly dismissed. Their reasoning? Well, they acknowledged that questioning the Domestic Violence Act is a big deal, sure, but it just didn't have the absolutely pressing urgency required to skip the lower courts. On top of that, they pointed out a massive flaw. Omar hadn't even properly cited the responsible minister in the direct access application itself. The court made it clear they really needed the benefit of a fully considered judgment from the High Court first before stepping in. Now, what's really interesting about this ruling is the court's highly specific wording. They wrote, "The failure of the executive to put its views before a court cannot deprive an applicant of having an application for constitutional relief adjudicated." This is actually a huge victory for Omar in principle, even if it didn't help him right that second. The Constitutional Court drew a line in the sand. They said if the government just wants to sit on its hands and ignore a case, a judge cannot use that as an excuse to ignore citizens' constitutional rights. Because of this ruling, Omar was explicitly told he was fully entitled to march right back to Pietermaritzburg, re-enroll his case, and demand his day in court. But wait, before they completely wrapped up the judgment, the court threw in one final, highly specific, and honestly kind of wild detail: the number 25. This random number ended up being a wildly embarrassing and fatal procedural error for Omar's team. Here is what happened. When Omar's legal team, Zahir Omar attorneys, went to the registrar of the Constitutional Court to file this whole Rule 17 application, they hit a tiny, ridiculous snag. Rule 17 says applications must be lodged, and Rule 13 is crystal clear. Whenever you lodge a document, you have to hand exactly 25 physical copies over to the registrar. Well, the registrar asked for the 25 copies, and Omar's attorneys literally just refused. No joke, they just wouldn't do it. The court noted that this blatant refusal to follow basic rules, especially without even filing an application for condonation, which is basically formally asking the court for forgiveness, was a completely separate, perfectly valid reason to throw the whole case out. It is definitely worth taking a second to appreciate the sheer weight behind this procedural reality check. This wasn't just one grumpy judge. This unanimous dismissal came from an absolute powerhouse roster of South Africa's top legal minds. We're talking Chief Justice Chaskelson, Deputy Chief Justice Longa, alongside Justices Ackerman, Goldstone, Madala, Mogoro, Mozanike, Ngobo, O'Regan, Sachs, and Yakub. 11 constitutional heavyweights all looking at this and agreeing that, hey, procedural integrity matters just as much as grand constitutional theory. Ahmed Raffik Omar's journey is a fantastic reminder that the wheels of justice demand rigorous administration. You can't simply skip steps or, flat out refuse to make photocopies, no matter how vital your constitutional claim feels. So it leaves us with this big question to reflect on. How do we successfully balance the swift, potentially life-saving intent of laws like the Domestic Violence Act with the strict, unyielding procedural rules required to actually challenge them? It's a tough balance for sure.